Good afternoon and welcome to the Appellate Division First Department. I will give you my usual spiel. We have 6 hours of requested argument time, and we have a full courtroom, it looks like. So I can assure you that your colleagues at the end of the calendar would appreciate your brevity. So I'm going to ask you to ask for just the time that you actually need, not the time that you want, understanding that we are fully familiar with your case, the briefs, the law. And understand that the clock is for you, not for my colleagues, so that if they have extra questions, because you're so brilliant that they need to ask more, I let it roll, okay? All right. People versus Roderick Hatton. Submit. Mancilla and Fantone versus Lou. Okay, 2 minutes. Arkira is a submit. Tversky versus Yeshiva University.
Yeshiva Appellate, 5 and 2.
Okay. Respondents?
Responded. Kevin Mulder.
5 and 2? He said 5 and 2.
10 minutes, please.
Okay. All right. I'm going to do the 5 and 2 and 7 to even you guys out. And if we have more questions, we will continue to ask. Salas versus Zolan. Okay, how much time, sir? I received your request after the end of the day, so didn't have time to respond. How much time would you like? Okay, I'm going to give you 5, seeing as you have no opposition, okay? And just so you know, I will be recused on that case, and Judge Moulton will, okay, I'll do it next. It seems I jumped over a case. Cassie versus Trump Management. Okay. 5 and 2 and 5. Will be Sandler Disclaimer Trust.
Excuse me, Michael Vogel for Appellate, request 6 to Your Honor.
Okay.
Leo G. Kalis on behalf of the respondent. I'll go with 62.
Do you have a cross appeal?
No.
Then you don't get the extra 2. So, all right, 6 and 2 and 7. Salas versus Zolan, we already said 5, and I am recused on that case for obvious reasons, sir. Cullins versus Ihime Gabu. And forgive me if I messed up the last name.
Appellant, 2 minutes, please.
Okay.
Respondent, 2 minutes also, please.
Okay, 2 and 2. 417 North Comanche versus Emirates 2.
Good afternoon, Your Honor. Charles Scholar for Appellant. We request 10 and 2.
Okay.
Mike Chisano on behalf of the respondent. We respectfully request 12.
Okay, I'm going to give you gentlemen 7 and 2 and 9. And like I said, if you're brilliant, you'll get more questions, so you'll get up to the number you asked for. All right, People v. Amadou Diallo. Submit. Lee versus Lee.
Your Honor, for the appellant, I request 10 and 2, please. Lisa Zeiderman for the respondent, 12.
Okay, 4 and 1 and 5. This is not that complicated. Okay, Peter versus Mayumi M. Submit. Reyes versus Benton.
Appellant, Gina Longobardi, 5 and 2, Your Honor.
Okay,
Respondent request 5, please, Your Honor.
5 and 2 and 5. Wilmington Savings Fund versus Scafidi.
Appellant Harold Vogel, we request 10 minutes.
Okay,
For respondent, we request 5 minutes.
5 and 1 and 5. Bodenchak versus 5178 Holdings.
Appellant, Jonathan Kortmansky. We request 8 and 2.
4 and 1 and 5. People versus Corey Powell. Submit. Zimmerman versus 41057 Corporation is a submit. Doe versus Mata is a submit. First case on the calendar, Mancilla and Fantone versus Lou.
Step up.
Good afternoon, Your Honors.
Good afternoon.
Briefly, this is an anti-SLAPP case, a strategic lawsuit against public participation. The lower court properly held that anti-SLAPP analysis applied, but erred in its application of that analysis. The defendant appellant left some bad reviews about her attorney online who brought defamation claims. The three quick points. One, the standard is higher on a 3211G motion to dismiss. Actual evidence is required of each element of defamation. Two, there's no evidence presented, much less specific allegations of actual malice, knowledge of falsity, or reckless disregard for the truth. There are some conclusory statements in the amended complaint of falsity, but there are no allegations or even evidence presented of actual malice. And three, the actual malice element is specifically controverted by the affirmation of the defendant appellant that explained why she believed to be true what she wrote. So the operative question is not whether any particular statement was true, and we argue in the brief that they almost all were, especially if read in the context of online reviews of an attorney. But the operative question is whether she believed them to be true or not, and her affidavit says that she did.
Counsel,
Yes.
could you reference the statements regarding the withholding of the retainer after the services of after the end of the attorney-client privilege,
Yes, so the
or
retainer,
relationship, rather?
right, so the plaintiff's respondents admit in the respondent's brief, page 24, that only 85% of the unused retainer was returned on March 14th, 2022, while the remaining 15% was returned on May 10th, 2022.
Yeah, but that's not what your client said. She didn't say, I got back 85 and 15 took me longer, right? She said, I wrongfully didn't get it back, correct?
She said
That's
she got it
pretty
back
easy.
eventually.
That's pretty easy to determine whether that's true or false. So that automatically, I think, or at least on a pre-answer motion to dismiss, would show not a statement of opinion, but a statement of fact capable of being proven true or false, right?
So in her affirmation, the defendant appellant stated, Mr. Fantone claims that I falsely accused him of holding onto my retainer for 3 months. He quit and filed a motion to withdraw in February 2022, but didn't return the full amount until May 2022.
But we're talking about what she said online. That's her statement afterwards, and this is a pre-answer motion to dismiss.
Right, but it's also a
So
3211G.
if what is said online is not what she's saying in her affidavit, and what we look at what is said online, he wrongfully retained my deposit or retainer, that's capable of being found true or false, correct?
That's a matter of interpretation. If
All
you
right,
look at it
and
from
we
the-
will do the interpreting. Thank you so much. Tversky versus Yeshiva University. Justice Michaels is recused on this case. Should we have a tie, we will follow Appellate Division First Department procedure with respect to that. You may proceed.
Thank you, Your Honor. Rolando Acosta, Pillsbury Winthrop for the Yeshiva appellants. I have to admit, it does feel a lot better on that side of the well. If Your Honor may allow me, let me just try to frame the issues for the court with three positions that have been laid out by the U.S. Supreme Court, Second Circuit, and the Southern District. Back in 1898, the U.S. Supreme Court told us that it is not within the power of the legislature to take away rights which have been once vested by a judgment.
So let me ask you, let me jump right in. No, we've read this all, we know what this is. What right are you saying is being taken away from you? Describe the right to me that you think is being taken away.
The property right is one that is vested in a final judgment that was issued by the Southern District twice.
You have a property right in a judgment?
Yes, in
How about a
fact,
judge-
that's what the Second Circuit has told us, that's what the Southern District has told us.
Regardless of what the judgment says? What if the judgment is, I dismiss because you didn't serve properly? Do you have a property right in that?
No, because that would not be a final judgment.
So we're
That would
talking
be an
here.
issue of lack of jurisdiction, and on the Federal Rules of Civil Procedure 41B, that would not be a judgment on the merits.
Well,
That would
is
result in a
is
final
statute of limitations a judgment on the merits?
pursuant to federal law, which is the law that governs the federal vested rights that we are asserting.
Why
That
does
is
the
a decision
federal,
on the
why does
merits.
the federal law govern here when what we are evaluating is the constitutionality of a New York statute?
Because the vested rights doctrine, Your Honor, the way that it has developed, and as it was cited in Luxford, for example, 95 years after the U.S. Supreme Court laid it out, the fact is that we are, as defendants, we are entitled to a property right under a judgment that's issued in federal court. Imagine.
But not any judgment, we agree, not any
It
judgment.
has to be a final judgment.
And it has to have substantive, it has to be on a
It
substantive
has to
issue,
be,
right?
it has, absolutely, it has to be.
So that's why I keep coming back to whether statute of limitations,
Right, well, but
isn't that basically just getting, denying someone a remedy?
Yeah, well, and notwithstanding, well, notwithstanding that our vested property rights are rooted in federal constitutional law, Your Honor, this is the argument that the respondents raised. That's the
Well, some other courts have found that persuasive too, right? There's two ways
right,
going to this.
but that to me, that is simply incorrect. If you honor, the flaw in that analysis, Your Honor, is that appellant's underlying substantive interest is not in respondents in a statute of limitation or in some procedural matter. They are based, as the Second Circuit told us in 1256, Hertel, is in a constitutional right that the respondents have to their finality. That's the whole nature of the vested rights doctrine. That's why it has lasted. I mean, just imagine, Your Honor, if the Brown versus Board of Education, if the Arkansas legislature decided, as they were unhappy with the decision that was made by.
I mean, you've definitely picked up the rub, right? If you take a statute that nobody thinks is a good statute and revive a claim under it, whether or not someone
That's
has.
right, Your Honor. And it's not that the New York State legislature doesn't have ample powers to pass the CVA and apply it to future proceedings and to pending actions.
So
It may even try to apply it retroactively, and I know that that's an issue that's still being litigated. But the fact is,
if
that they
I
do
might ask you a question, if in Hertel, it seemed that the court focused on whether the governmental action had affected a party's interest in some way. That wasn't their focus, but rather the extent to which the challenged governmental action had upset claimants' invested back economic expectations by altering its rights as to a constitutionally protected property interest. So my question is, what invested back economic expectation was upset by this ruling?
Well, it's interesting, Your Honor, because the Second Circuit in that case framed the issue. Let me just read it to you. The crucial question in this case is not whether Hertel's judgment lien is categorized as a property interest by New York law, but whether it constitutes a property interest for purposes of the 5th and 14th Amendment. That, and I'm quoting now, that determination, despite its state law underpinnings, is ultimately one of federal constitutional law.
Yeah, but the Supreme Court has never applied that doctrine in the way that you are asking us to apply it today, right?
The U.S. Supreme Court?
Almost every single case involved a property interest, a security interest, a judgment for money. Here, what we have is a judgment dismissing a case on statute of limitations grounds. So again, to me, the issue is, what is the property? For me to even begin the analysis, I have to understand what is the property interest that the claimants are asserting has been violated. And I'm just grappling
Yeah.
with how the dismissal on statute of limitations grounds in federal court for a New York statute vest your client with some vested property interest that has underpinnings under the Fifth Amendment of the
Well,
Constitution.
the property interest is based on federal constitutional law, Your Honor. And it's the interest, I mean, if you look at how the court does the analysis in Luxor, for example, it talks about vested in a judgment in finality, expenses of litigation, having had to litigate.
So it's like a property interest in repose. Is that what you're saying? I mean, I know you're saying judgment is important, not necessarily the repose given.
But the property interest is in the judgment itself. Once a defendant goes through the judiciary.
But here the judgment was a dismissal, not you're right, you win, here's $5 million, that's what they owe you. That's clear. That is a vested interest in something. Here, the something is we got a dismissal and we want to keep that dismissal because we want to be able to avoid the legislature of New York State, which did this revival statute. So,
Well, a dismissal based on the statute of limitations is an adjudication on the merits. This court itself in Kamlosi recognized that. This court made it clear that claims dismissed in federal court, and I'm quoting you now, very distinguished panel in 2004, Justice
I'm gonna
Nardelli,
be on it,
Sullivan,
right?
saying, well, this was 2004 before.
Okay, so good.
So they made it clear that claims dismissed in federal courts, including those dismissed on statute of limitations grounds, were adjudicated on the merits. That's Kamlosi versus City of New York, 383rd, 343. This department, Your Honor, a panel of this court addressed that issue. So it was on the merits.
All right, you'll have time on rebuttal. And don't worry, you'll get some equal time, okay?
Your Honors, respectfully, the fatal flaw in the defendant's argument is that they do not correctly state what the alleged nature of the protected property interest is in the prior federal judgments entered in 2014 and 2015. Judge Acosta cites Hertel. Hertel says, okay, we look at a federal constitutional issue, but we must first, as a threshold matter, must, not maybe, not perhaps, must first examine what the state law provides are the contours of that protected property interest.
So does state law provide for a property right in repose? In other words, the right to be left alone from lawsuit arising from a certain nucleus of operative facts?
Absolutely not. If you look at the Megan S. case, the Court of Appeals, 1987, the Court of Appeals basically determined that a decision on a paternity proceeding was not entitled to res judicata effect because there was a supplementary.
But what about the federal law? I mean, we're talking about a 14th, not the New York State constitutional law. We're talking about federal law. And isn't it true that under federal law, a dismissal on statute of limitations grounds is a dismissal on the merits?
Absolutely.
So then if we're talking, so the question, if you're looking at federal law, is do I have a right to be able to, one, depend on that dismissal when 20 years down the line I'm figuring out how much insurance I owe, how much I should buy, who I should hire and fire, all these things that depend on my understanding that I don't have that potential liability anymore.
The fact that it's on the merits, though, Your Honor, does not mean that that it has a constitutional protected right. Hertel says that it says you have to look back to the state law. You know, the federal law says first look to state law. They didn't do that here. In fact, they waived any argument that state law applies because they consistently say in their argument on both briefs that state law is entirely irrelevant to the issue. It's not irrelevant. Federal law directs the court to re-examine state law. And, you know, if you look at the Perez v. Kipp case.
Even in a situation where federal law and state law are not in congruence, and we're looking at a federal statute, the Constitution, actually, the federal Constitution, I find that hard to believe that the federal courts would say, we're not going to apply our own federal law on a federal constitutional claim under the 14th Amendment. I don't think that's correct. That's
Well,
my problem.
Well, it's not that they don't say they're not going to apply their own law. What Hertel says is that they first have to determine what the property interest is in the state law and then apply the federal law to that. Am I correct?
That is correct. And in fact, the town of Castle Rock case, the Supreme Court says that when you examine a federal constitutional due process case, we must first look to find what does state law provide on that issue. That's the federal Supreme Court saying state law is preeminent here. And
Well,
this-
it's preeminent in determining whether there's a property interest.
Yes. And if you look, Your Honors, I respectfully ask you to look very closely at the Perez v. Kipp case decided by the D.C. District Court in 2024, which is directly on point and on all squares with this case. The defendants say that it was irrelevant. Not only is it not relevant, it's controlling. There you have the same thing as we have here. We have a state revival action, reviving sexual abuse actions. You have an issue of a dismissal in federal court with a federal judgment, final judgment, barred on statute of limitations ground, revived. And the Perez v. Kipp court had two separate rationales. The second one I'm going to get into because it's easier, and it kind of lays the issue to waste. The Perez v. Kipp court said that this does not, the second act, the revival act, does not infringe or impose upon the protected property rights that the defendants may have in their prior earlier federal judgment. That is because the one case is involving the prior law, second case is involving a subsequent law giving new rights, subsequent rights, and because of that, the judgments obtained in the prior federal cases are independent from the judgments that are going to be obtained, in this case, under the CVA. Now, that's the exact same analysis that we have before the court.
Except what if you bring suit in federal court as opposed to New York State court? What happens then?
I think the analysis would be the same, Your Honor, but we're not bringing it to the federal court, we're bringing it to the state.
But I'm saying, I mean, isn't there a potential for inconsistent decisions based on whether you're bringing your case in federal court or state court?
Perez was a federal court. It was a federal court doing the same issue. It's a consistent application of the law. There's no inconsistency there. You must look to see whether it impinges on the law.
Well, I mean, there are cases going both ways, so it's clearly inconsistent. There are consistent
this,
applications. That's, I think, what we're all
I've
struggling
been
with.
a lawyer for 35 years. I've never seen an issue more all over the map than this particular issue. But I would say, if you look at the equities of this case, you have plaintiffs who did not sit on their rights. These are plaintiffs who found out about YU's cover-up of their sexual abuse in 2012, late 2012. By 2013, they had filed a federal claim in order to assert their rights. They didn't sit on their rights. They were asserting their rights aggressively. Their argument and their rationale that they asserted in the federal court in 2014 and 2015, which was rejected, the same exact issue was adopted by the Sixth Circuit Court of Appeals in the case involving Ohio State cover-up of sexual abuse, Snyder Hill versus Ohio State University. So the equities here, and the defendants acknowledge this. It would be a gross inequity to punish the plaintiffs who had the courage to file suit soon after they found out YU had engaged in a conspiracy. It's a gross inequity to punish them, especially because it's clear that federal law must have state law as part of the equation. It cannot bump out state law. It just can't. Every case that I cited in my brief says that rule. And if I could make one more argument, just briefly, there's another issue. We look to define the contours and dimensions of state law in order to determine the depth of the alleged protected property interest. Res judicata is an issue that's constantly been talked about. What is the preclusive effect? Here, this court should look to New York state law on res judicata issues as the Perez court directs. The first element in the vested rights analysis was this is not entitled to vested rights. There are no vested rights implicated here because res judicata does not apply because there was judgment not on the merits without prejudice. Here, this was with prejudice, the federal cases, but New York law, as the Megan case says, pages 40 and 43 of my brief, very clearly, that a subsequent legislative act will be given effect and will not have res judicata impact on a subsequent suit brought under a new revival statute giving the litigant additional time and enlarging the time of the statute of limitations. So Megan S., which I cited prominently in my brief, 4 pages, 40 to 44, was ignored entirely. There's not one word in the reply brief by defendants on Megan S. So respectfully.
Well, they do say that claim preclusion is not the equivalent of vested rights. That's their main argument. I mean, that's their crucial point they make.
It is, but Perez disputes that. Perez, at page 22 of the decision, is a Lexis site, so I'm not going to give you the full site. But Perez says very clearly on page 22, the first issue on vested rights, and I'll quote it, to the extent that defendants have a vested property right in the court's earlier judgment, that right is limited by and subject to plaintiff's right to file a new suit based on the same claims. So they're saying if you can file a new suit on the same claims, if you don't have a race judicata impact, there's no vested right. We have the same thing here. We can file a new suit based on the same claims as clearly mandated by the Court of Appeals in Megan S. Thank you, Your Honor.
Thank you so much.
Your Honor, the prior plaintiffs admit that this was a judgment on the merit, rejected twice by the Southern District, affirmed by the Second Circuit, reconsideration denied, in-bank review denied, certiorari denied by the U.S. Supreme Court. So there's finality. This is with prejudice. The cases that they're citing, not one of them involves vested interests. It involves res judicata or issue preclusion claims.
What about Cloverleaf? Cloverleaf makes the point that, if you can't bring it because of shorter statute of limitations in state court, you can bring it in federal court. That's Second Circuit.
And I will, if I may just cite, because I know they cited Perez versus Kip.
Similar.
I just want to cite to the court what Perez versus Kip said. It was the court, and I'm quoting, the court's earlier judgment without prejudice, which is an invitation to the parties to refile. So it was without prejudice and not the legislation that allowed the suit to continue in KIP. And that's KIP 2024 3334769, DDC July 25, 2024. Now, the lower court, Your Honor, cites both to Adler and Cloverleaf. Both cases cited by the motion court for the proposition that while it is true that it is not within the power of the legislature to take away rights which have been vested by judgment, so they acknowledge it, but then the court takes the wrong direction. This rule does not apply where the judgment is based upon the defense of statute of limitations. Our judgment is not based on the statute of limitations. It's vested on a final judgment granted in federal court.
But it was granted on statute of limitations grounds, right?
Which is on the merits, according.
But it's still on statute of limitations grounds. So
It is, Your Honor.
any case law that talks about that issue would be relevant to this case, right?
Well, it will. This court. Let me just cite to this court's precedent. This court in Conlosi say no, that we are bound by federal court in its decision that statute of limitations grounds are an adjudication on the merits. That's a quote from your own from Conlosi in this court, Your Honor. So with respect to Cloverleaf, Justice Moulton, first the proposition Cloverleaf is a case involving not a final judgment, not a vested right on the Cloverleaf, and neither is Adler. On the Cloverleaf, it involves a New York State court case about the New York State Constitution, which did not involve vested rights. So I don't know why the lower court cited to Cloverleaf. Adler is not even good law, Your Honor. Adler involved the very same retroactive statute that the U.S. Supreme Court invalidated in Plow, found unconstitutional in Plow, and that's the 15 U.S.C. Section 78 AA/1, where the court basically found 2 years after Adler that it could not revive claims following a final judgment.
I mean, that was, in Plout, that was a separation of powers analysis.
It is, Your Honor. It's a very same separation of powers because separation of powers, if you read the law, and I know Your Honor has, the Luxford decision, the Luxford decision talks about the two main components of vested rights doctrine. The due process component, which we talk about, our property interest in the vested judgment cannot be taken away without due process of law based on the Fifth Amendment, applies to the state through the 14th Amendment, but also is the separation of powers component preventing Congress or any other branch of government from sitting as a court of error, is the way that Luxford talks about it, to the judiciary. We cannot have any legislature, whether it's Congress, and frankly, you know, I'm not going to go into the separation of powers issue at the state level, but you cannot have the state legislature pass an act that deprives people of property, defendants who have a vested property interest, of their constitutional right willingly.
I agree with you when we are talking about property, but that's not what we're talking about here, and it is under advisement. I thank you, gentlemen.
Thank you very much, Your Honor. Thank you.
No, that's not how we do this, but have a good day. That's not how we do this. Have a good day. Thank you so much. All right. We will wait for my colleague to return to the courtroom. Next case on the calendar, Kasai versus Trump Management. You may proceed.
Good afternoon, Your Honors. My name is John Sandercock, and I represent the appellants, the defendants in this action. I may want to make 2 points. First is that the plaintiff has no evidence that the defendants had notice of the condition that caused him to fall, and the motion court should not have considered the hearsay affirmation of the plaintiff's cousin.
Why not? Mr. Kaplan is the cousin, right?
Yeah,
and he
yes.
said, you know, I saw other people falling in the area where the defendant fell. Isn't that enough, at least at this stage?
His observations are not hearsay.
Yeah, he's a, right.
Well, it's not his observation, it's what someone told him.
He was there. He said he saw people fall. Those are his observations. He's completely entitled to testify about them, and that's not considered hearsay and perfectly admissible evidence at this stage. So what's the problem?
Well, even if the statements are admissible under CPLR 4549, they don't raise an issue of fact.
No, but that's a separate issue. That's what the plaintiff heard from attendants, correct? That he said that he was advised as he was helped off the rink.
True. That
other people had tripped there. And it seems like that is maybe an exception to hearsay under 4549, because they've gotten, 4549 was amended in 2021 to get rid of the speaking agent rule.
True.
So it sounds like that's also, competent evidence.
Well, if you would consider that this accident occurred in 2018, and so you would be applying a retroactive standard.
I don't think that's a strong argument, counsel. I think we have to apply it.
All right, I'll just point out that the Appellate Division hasn't really considered this issue.
Excuse me?
The Appellate Division has not given a whole lot of consideration to whether that statute should be applied retroactively.
Well, that's your opinion, and you're entitled to it, sir.
Oh, all right, fine. I would also like to say that the plaintiff has no evidence that the defendants created the condition that caused him to fall.
Yeah, I don't even think the plaintiff argues that, though. Maybe that they argue that it should have been cut one way or another way, but really the issue here is, did the defendants have actual constructive notice, right?
Right.
And so there's two things. There's the alleged party statement, which may or may not come in, depending on whether or not the plaintiff can actually prove that the person they spoke to was an agent of the other party. But there's also the person who, the cousin who saw other people falling, saw your skaters going over and helping them up and helping that. Those two things raise an issue of fact of constructive notice, right? No?
Well, no, not necessarily.
How come not the cousin?
Because seeing people fall is not evidence that they were injured.
I don't know, if there's a slip on the, if there's a banana peel on the floor and 5 people fall on the banana peel and the store manager doesn't go over and pick up the banana peel,
Well,
I feel pretty confident that we would say
well,
that that was.
this is an ice skating rink.
Right.
This is
So
not a
if there's like the rough, it's unnaturally rough or not supposedly rough, and 5 people fall, and then this plaintiff goes over and falls, and there are there are skaters from the defendant's organization going around helping them up, pick them up. Why wouldn't that create an issue of fact?
because there's no way of knowing whether any of them were in fact injured.
Oh, well, I mean, that's an issue of credibility, right? Who knows if he's telling the truth? Well, we'll let the jury decide that.
Okay, my time is up.
Thank you.
Good afternoon, Your Honors. Brian Isaac, I represent the plaintiff respondent. I'm prepared to rest on my brief. I just did want to say one thing, although I see how you know the record. There's even an issue of fact as to whether there was a rut there. When you read the report, the incident report says it's pristine. We have plaintiff and we have his cousin saying there are ruts all over the place. People are falling. The guards are going over there. Yeah, I can't say for sure that the guards knew what was going on, but if a guard ring goes over and sees people falling, I think the argument is you have to see what's there to be seen. So my argument's very simple. The trial court didn't get this one wrong, and you should affirm. Thanks for listening to me.
Counsel, you have a minute on rebuttal. Do you wish to exercise it?
I think I will rest on the brief.
Thank you so much. Have a good day, sir. Wilby Sandler Disclaimer Trust versus Swirsky. You may proceed.
May it please the court, Michael Vogel for the defendants and appellants. The lower court here dismissed on a 3211A7 motion properly pled and meritorious counterclaims. The claims and counterclaims in this case all arise out of the conduct of Will Sandler, who was the predecessor in interest to the plaintiffs, who unethically wrote himself into his client's real estate transaction for his own personal benefit in violation of Rule 1.AA of the Rules of Professional Conduct, which required that when a lawyer engages in a business...
So that's a legal malpractice claim, correct?
Well, it may be legal
That's one of your two
malpractice.
counterclaims, right?
Counsel, when one of the judges is talking, you should let them finish their questions.
Good rule
My
of thumb.
apology, Your Honor.
You have two counterclaims. One is for rescission, one is for legal malpractice, correct?
Yes.
Okay, so how can you have a legal malpractice claim against someone who's not a lawyer?
Okay, so the legal malpractice claim arises out of the same transaction or series of transactions, which was the creation of this property interest that plaintiffs are...
No, but Muriel Sandler can't be liable for legal malpractice because, as far as I know, she's not. If she is a lawyer, she wasn't involved in this transaction herself.
Well, the answer is that as an assignee, you step into the shoes of the assignor and you take subject to all of the defense.
No. You're talking about suing the claim. We're talking about can you state a claim? Not whether you can ultimately get relief against that party, but whether you can state a claim. And I think what my colleague is saying is, how can you state a claim for legal malpractice against a party who is, 1, not a lawyer, and 2, did not represent you? The question of whether you can ultimately get a remedy against the trust is a separate question. You've pled a malpractice claim against someone who didn't represent you and to whom is not even, the trust obviously is not a lawyer. So again, we're left with, how could you do that?
Okay, can I answer?
Separate out the remedy.
Okay, I would answer that in 2 ways. let's imagine the situation where I, as an attorney, assign my account receivable.
I want you to answer the question directly, not by way of hypothetical, because now you're asking us to answer your question for you.
Okay.
You answer the question. Don't give me a hypothetical. How do you sue someone for malpractice who's not a lawyer and who didn't represent you?
Because
That's the question.
the answer is because an assignee takes subject to all of the defenses.
An assignee takes, when I get assigned a share of stock, you're saying I can sue the person who 25 years ago created the company? I've never seen that before. I don't think that's the law, and I'd like you to explain to me how assigning a property interest would transfer a malpractice claim. That is different from whether or not, ultimately, if you prove the malpractice, you can get a remedy against the trust. That's a different question.
That would open up every single lawyer's probate case to this kind of action. So anytime a lawyer dies, their spouse has to worry about litigants coming out of the woodwork saying, oh, your husband or your wife made a mistake on my case 15 years ago, and now I'm going to sue you for it? Okay. That's what you're saying here.
Your Honor, I understand that the answer I gave as to legal malpractice was not persuasive. I don't think I have another answer for that. May I focus then on the enforceability or unenforceability of the underlying agreement, which violates Rule 1.8?
Absolutely.
And that was not contested by...
Again, that is not, you say, my claim is for rescission. Rescission is not a cause of action. Rescission is a remedy, an equitable remedy that one may get. The same way piercing the corporate veil is not a cause of action. It is a remedy. Rescission is one of many remedies that one can get for breach of fiduciary duty, which you've pled, and breach of a professional responsibility, which you've pled. Again, these two plaintiffs don't owe you any fiduciary duty, so you have no claim for breach of fiduciary duty against them, and you have no claim, again, with respect to breach of professional liability. They are not lawyers. They have no duty to do that. Once you get, if you prove your claim, if you have a claim against the party who you believe breached his fiduciary duty, then you've got lots of remedies available, and maybe rescission is one of them, and maybe it isn't, but it's not a cause of action.
Your Honor, respectfully, there's no question this agreement would have been unenforceable in the hands of Mr. Sandler. And Schlanger versus Flatten from this.
So then sue his estate. That's the whole point. If you want to go after the fact that he did something wrong, sue his estate. But you can't sue the people who have no duty to you. The trust has no fiduciary duty to you. How can you sue the trust for breach of fiduciary duty?
And you started your argument by saying, this man breached his responsibilities by writing himself into the contract, as though the record doesn't show that for 30 years, this man and your clients were engaged in business. So the fact that they had a contractual agreement in their transactions was not unusual in the slightest, based on this record. But you'll have time on rebuttal to address it. You'll have time on rebuttal to address it.
May it please the court, Leo G. Kalis on behalf of the Sandler Trust. I don't think you'll need a microphone. This case is actually controlled by a decision, 3 decisions, 2 in the Appellate Division, First Department, one of which the Glidcat case, 2 of the judges on this panel sat on it. And given that the counterclaim did not arise out of the same transaction as alleged in the complaint, and they seek distinct damages, the doctrine of equitable recoupment codified in section CPLR 203D is unavailable. The Court of Appeals case is even closer to our facts. They're basically complaining about actions happening before the contract was made. And the Court of Appeals said the tenant's claim relates to the performance under the contract. The landlord relates to the negotiation and articulation of the agreement made by the parties before the execution. While on the most general sense, both might be said to be associated with the lease, the language in CPLR 203, subdivision 3, the claims do not arise out of the same transaction or occurrence. The claims that he's asserting on behalf of Mr. Swirsky, they do not arise out of the same transaction. What we're suing about are K-1s that Mr. Swirsky issued in 2019 and 2020 to the estate. Those are the facts that we're focused on. Ultimately, yes, it's based on the original LLC agreement, but what it's really based on are statements made by Mr. Swirsky in 2019 and 2020.
No, but I mean, so what? Because if you have a counterclaim against someone, it doesn't have to be related to the same transaction. You can sue you can sue for whatever counterclaim you have. That, you know, it doesn't have to be related. Counterclaims can be asserted in any event. If I have any claim against you, it doesn't have to be out of the same transaction.
I understand.
So that can't be the end of this.
No, he's trying to revive a time-barred claim. That's what he's.
Well, okay, so that might,
That's where the difference.
That might be
and that's
something
where
else, right? When does the claim,
C and D,
right,
It's an exception.
right.
It's a rare exception. And
If it's a breach, the breach happens, right. The breach happens when the agreement is entered into, right? In 2004.
2014.
Right, 14.
We're
Not
talking
when,
about events in 2019 and 2020.
no, but so that's a different thing to say, and not only that, but it's barred by the statute of limitations.
Yes, it is barred by the statute of limitations. That's the focus, and the sections that I'm relying on are the K-1s that were issued in 2019. That's in the Appendix 133, and the K-1 that was issued in 2020, which is, that is 139. And then the lawyer's note, Mr. Swirsky's lawyer actually admitted that monies were owed, and that's in 157. And they're basically they're struggling to find something to defeat the estate's claim. And the one last thing I want to say, when I was in law school, the professors always referred to the widow and orphan claims. This is the first time I'm representing a widow, and I sort of thought it's an interesting footnote to my career.
Thank you.
May it please the court, just to
I'm
make.
going to give you his leftover 23 seconds. You go ahead.
Thank you. I will try to be brief, but I do have a few points to make. In terms of Your Honor's point about the length of their relationship, that is disputed. There was a long-term relationship, and we can get into the facts of how it got brought in, but that Schlanger versus Flatten involves exactly the same situation. It's a multi-decade relationship, and the agreement was found to be unenforceable as to the lawyer. And my submission to Your Honors is, if the principle of law that an assignee stands in no better position than an assignor and is subject to the same defenses is to mean anything, it has to mean that a defense of the unenforceability
Yes,
of the agreement
that is
underlying the claim.
that is a correct statement of the law, but it is not in a vacuum, sir. There are other laws that impact that principle, and we've laid that out in your first go-round.
I'm submitting that to Your Honors.
We don't disagree with what you've just said. That is a stated, clear principle of law. But that doesn't end the day. There are other principles that interplay here in this analysis.
Okay.
So it doesn't stop at that, okay?
I understand. In terms of SCM, that he mentioned, that's prior to the Bloomfield versus Bloomfield case, which involves the same situation.
Can you address the statute of limitations issue here?
Yes. 203D says that we can assert claims that arise out of the same transaction or series of transactions as the claims asserted. The enforceability of an agreement on which claims are made arises out of the same transaction or series of transactions. We cited for that Bloomfield versus Bloomfield in the Court of Appeals, which holds that 30 years after a prenuptial agreement, you can assert the defense that the prenuptial agreement is unconscionable and cannot be enforced. Also, XLO Concrete in this court, which held affirmed by the Court of Appeals that under the Donnelly Act, unenforceability is timely under 203D. And then finally, just very briefly, since opposing counsel mentioned the K-1s, those are outside of the record and were attached unsworn to a reply brief, which I objected to at oral argument. And likewise, they've relied on settlement discussions, which are inadmissible. We do dispute liability.
Thank you so much.
Thank you, Your Honors.
Salas versus Zolan. I am recused on the matter.
Please,
Can I proceed?
please.
Yes. Good afternoon, Your Honor. I'm sorry, I really want to apologize for my accent. The case before you is an Article 78 proceeding against a referee. This court appointed a referee to conduct a liability hearing against me on ethical proceeding. I was accused, I practice immigration law, I was accused of using a particular immigration form to generate work permits for parents of US citizens and for some LGBT. At the criminal trial, I
Mr.
wanted
Salas, one issue you have is that can you attack the disciplinary proceeding collaterally through this Article 78? Is that allowed?
Yes.
I mean, I would say no, based on my research, but convince me I'm wrong.
No, I'm attacking this referee. The referee determination, which is against the jurisdiction, is also against, the forms of evidence on file. So, but this referee, rather than conduct liability hearing, he went on to, be a biased referee. He ran a biased tribunal. At the beginning of the hearing, before conducting liability hearing, this is what he told me. He said, I'm going to sanction you. It's time to sanction you. But we have not done any liability hearing. Okay, we continue. I said, I won the criminal case. He said, of course, you did not win. You just dodged the bullet. All these are before you. So he ran a completely biased tribunal. And I presented a lot of documents before this referee. There's only one evidence that was presented. This evidence is in Exhibit 83. The evidence is from one Stops. Stop is saying that the form that I used to generate work permit for this client, that you cannot use the form to generate work permit. But I show proof from his bosses that the form can be used to generate work permit, and the work permit were issued.
To generate what? I'm sorry.
To generate work authorization for immigrants. So the work authorization were issued to these clients. Now, Stops also testify at the criminal trial. When he testified against this exhibit. And this exhibit was signed by the ethical prosecutor. It was not signed by Stop himself. It was signed by the ethical prosecutor, Doyle. So my concern is, can ethical prosecutor sign a witness statement? Now, number two, this same ethical prosecutor instigated the criminal case against me. I have a letter with you by the New York District Attorney that the case was partly instigated by the ethical prosecutor, and I won the case. Then it went ahead, they wrote this ethical prosecutor also testified at the grand jury, testified at the trial, and he decided to also try this case. At the time they wrote this paper, the complaint to the ethical prosecutor, I already left the first department. I was in second department already, more than 5 years. But he insisted that he's going to try the case. So my question is, you instigated a case against me, you testify at the grand jury, you testify at the criminal trial, you also breached the conflict of interest, you want to take on the case to try the ethical case. So all the evidence, everything that I presented, they just ignored it and decided, oh, you are guilty. And then when I pointed a lot of things out to the referee just refused and, conduct a mischaracterization. He will mischaracterize manufacture wrongful conclusions, mischaracterize the argument, and then end up, to just make a determination that's against the forms of the evidence. I never see this before because I have to, now proceed on a federal civil rights action, against, the referee and the ethical prosecutor. Now, if you go on the background, I supply the background of this case. I happen to be a lawyer here. I discovered that a lot of immigrants were victims of slavery trafficking in this New York. So I presented their case before the USCIS. That, look, these are victims, parents of U.S. citizens and some LGBT.
Judicial notice of that. You don't have to establish that. Yeah.
Okay, thank you very much, and that's basically what it is. But the point is, all the evidence, the forms of evidence that I presented on file, the referee decided to ignore it. And if you look at this single evidence, this is the only thing they used to attack me. The only evidence from Dustin Stubbs. And Dustin Stubbs testified.
Sir, you make that point in your brief very
differently
well.
from this.
Are there any further questions? No. Thank you, Mr. Salas.
All right, thank you, Your Honor.
Collins versus Ihemeguba. Okay. But his name is relevant.
Good afternoon. Supreme Court was half right on this appeal. Dr. Lescano's 6-hour delay in providing the blood transfusion raises a malpractice claim, but so too does the hospital staff failure to timely follow through with that same order. So the direct claims against the hospital should have been restored. And we have a great case on the issue, Toth versus Glen Cove, 22 New York 2nd, 255. In that case, the nurses failed to follow through, allegedly, with the order to give the baby patient oxygen. And the Court of Appeals said that's a direct claim. And that's our main argument here.
Thank you.
Good afternoon, Fred Friedman for respondent. I'll try to be equally brief. Plaintiff's argument, predictable, we knew it was going to be. He said, well, if there are issues of fact as to Dr. Lescano, as to whether he followed up on the transfusion, well, then naturally there must be issues of fact as to the nursing staff and this blood bank. It's not right, though. I think this is what the case
Counsel,
law
how
makes.
do you rebut the case just referenced by your adversary?
Toth, they're saying?
Yes.
I don't think this is a Toth case for a few reasons. The most important one of which is that plaintiff never made any claims against the nursing staff, the blood bank. This first came out in opposition to summary judgment. Had there been a claim all along that the nursing staff did not follow a specific order from the supervising
But we knew
physician-
that from the record. That was clear from the record, right? There was a order for a transfusion, and 6 hours later is when this baby gets that transfusion. So clearly, someone dropped the ball.
I think we're kind of getting ahead of ourselves.
Well, I don't think so.
You're mad on this one, if you will. Even if you assume that we as defendants were put on notice of a specific claim against some unidentified
So when a doctor
nurse.
writes an order for a stat action on whatever medication, you're saying that the processing, the placement of that order doesn't automatically place the hospital on notice?
No, if that were such an
Really?
obvious claim, it would have been raised. Plaintiff would have
Counsel,
sought
in
discovery.
the bill of particulars, there was a claim put forward about failure to timely transfuse. How is that not notice?
100% there was a claim. But here is where I'm going to go back to the case law, because, yes, we know cases say plaintiffs, especially in personal injury cases, can get away with a broad BP, and then they expound on it on summary judgment. But what you can't do is, for the first time on summary judgment, identify entirely new providers, or in this case,
There is nothing new about this. There are people who are treating this woman and this baby. You know who they are. They're in your control, in your hospital, and your records tell you exactly who they are, who was treating, who was asked to do what when. Right?
Again,
So,
I'm sorry, I thought you were
yes,
still
please
going.
tell me again.
Sure. If the claim was that a nurse, unidentified as she or he may be, had done something specifically wrong, that the blood bank did something specifically wrong,
Well,
what
the
would
claim
any
was
plaintiff do?
the
They would
claim-
seek discovery from those
Counsel,
entities.
the claim was failure to transfuse, and I guess what my colleague is trying to impress upon you is that that would have been handled by the nurses, right? So that it's clear that it's not a surprise about who would carry out the doctor's instructions regarding transfusion.
I would say the courts have addressed this, where they specifically say you cannot lump all providers together, especially unnamed ones,
Okay.
and use that. And I'll just point you to, it's in our brief. I
Thank
won't
you
discuss
so
it.
much. Your red light has been on for some time. Thank you. You didn't ask for any rebuttal, so thank you both, gentlemen.
Thank you.
417 North Comanche Street versus Emrys. Hi.
Good afternoon. If it would please the court, I'd like to introduce my colleague, Charles Fowler. He's been admitted pro hoc vice, and I ask that he be permitted to argue this.
And where does he hail from?
He hails from Texas.
Ah, very good.
Thank you.
Welcome to our fair parts.
Thank you, Your Honor, and may it please the court. The lower court dismissed Comanche's tortious interference claim based on an earlier pending action in Hays County, Texas. And to frame my discussion today, I'd like to drill down a little bit on the nature of that earlier filed action. Comanche was the defendant in that action originally. We were sued by one of the defendants here, Emrys, and they obtained a temporary injunction from the Hays County court. Texas law, like many states, affords a limited protection to defendants who are enjoined, which is to require the plaintiff.
The bond, a bond that started at 500K and then went up to 3 mil.
Yes, Your Honor.
Thank you.
And
Counsel, can you tell us, just skipping briefly to the Travis County case, what is the status of that? Has the Supreme Court of Texas ruled on that yet?
Yes, Your Honor. The Supreme Court of Texas denied the petition for discretionary review on September 5th. We did file a letter shortly after that decision came down to alert the court of that development.
Oh,
So
good, thank you. I missed that.
The
me too.
default interest issue underlying this case has been conclusively resolved in Comanche's favor. So where I was heading with that is that, in effect, the lower court held that by invoking this sort of limited procedural protection to make a claim against the injunction bond, Comanche effectively forfeited its tort claims here in New York against the defendants.
What are the tort claims here in New York?
We have a tortious interference claim against.
Based on what?
Based on two core allegations, Your Honor. First, that Emmett, one of the defendants, entered into a contract to buy the collateral property from us, the lender, without our permission. That was in violation of Section 15
Okay,
of the loan agreement. And second, the act of actually suing and obtaining the temporary injunction, which.
So what is the action, the pending counterclaim in Texas for? Wrongfully getting an injunction, correct?
That is what the claim is.
Exactly what you're suing for here, wrongfully getting the injunction, which is also part of the entering into the contract, right?
There is, yes, Your Honor.
So, okay, the parties are the same, not all the same, but they're the same parties, same claim, same damages, right? Why are we doing this?
So I disagree. Well,
yeah, go ahead.
I disagree, Your Honor, and I think, you know, I
Are the
disagree on
parties
all
not the
three
same?
elements.
Are the parties here in the Texas case?
Let's cut to the chase. The damages aren't the same in Texas and New York. Why should we allow you to Why should we allow this case to be heard here when otherwise it seems to be duplicative of the Texas action?
I think two key points, Your Honor. First, we cannot get complete relief in the Texas action. Second,
Is that, I agree with you, but is that a basis upon which we can grant you relief here where there is a duplicative claim already filed somewhere else?
yes, Your Honor, because one of the three requirements for dismissal under 3211A4 is that the relief is substantially the same. And this court, for example, in the White Light case, which is one relied on by the defendants themselves, this court from 1997 describes that as complete relief.
What damages can't you get in Texas that you can get here?
So we're strictly limited to a claim against the $3 million that's been posted with the court.
Oh, wait, my understanding, so you're saying you can't get damages above the 3 million?
We absolutely are capped at the $3 million.
Are you sure?
In your complaint,
Yeah.
just looking at the complaint briefly, didn't your prayer for relief include lender's reasonable and necessary attorney's fees and expenses in connection with the cause, pre and post judgment interest, all costs of court? So that's some other additional amount on top of the bond, right?
As a matter of Texas law, I believe all we can recover is the bond amount.
$3 million, that's it.
No, but I mean, you're talking about a number. I'm talking about what kind of damages are you thinking that you can get here that you can't get there?
Yes, Your Honor. We have alleged that we've been harmed by the tortious conduct in this case to the
What, again, what damages?
She wants to know, do you have damages you can assert that exceed the $3 million bond that you have in Texas?
By far, Your Honor. One, we have alleged that we lost out on at least $7 million worth of lost rents that we would have collected had we foreclosed. Two.
But wait a minute, but you had to build the structure first, the building, right? And wasn't that being impeded by a bunch of contractors' liens?
That was completed back in 2021. During this entire relevant period, the building was operating.
So rents from 2021.
Rents were collecting. The only reason they weren't coming to us was the injunction. The second big.
But that would have presumably knocked down your loan amount, right? You don't collect the rents and then keep the loan amount. That knocks down the number you get ultimately.
Those are separate issues, Your
No,
Honor.
that is exactly, you're saying to me, there are damages that I can't get, and I don't see them. You could get those damages. You got them when you sold the property, so those aren't damages you can't get. What else?
We didn't get those.
Interest is a damage that you can get for the wrongful filing of the injunction. What other kind of damages do you think?
You say you didn't get the proceeds of the sale?
We eventually got the proceeds, but if we had foreclosed, for example, we would have been able to credit bid up to about $20 million, a little bit north of $20 million back when the injunction was first entered. Had we done so, we would have had the property and we would have collected rent that entire period. Let me touch on the other big category of damages that we believe that would have been available to us in that scenario that we didn't ultimately get from the foreclosure sale, which is our ability to, starting in April 2021 when we were enjoined, rehabilitate the property. It had been under the control and was during the whole period of the injunction under the control of the delinquent debtor who had frankly kind of got us into this mess in the first place. We believe we would have radically increased the value of the property. And
we'll get back to that later, but that aspect sounds very speculative, but you can address that later. Counsel?
Thank you, Your Honor. I'll start exactly where you just left off. As the court correctly notes, there's nothing that's prohibiting 417 North Comanche from seeking every bit of the categories of damages in Hayes County as they're seeking.
Is he correct that he is capped at the $3 million that's in the bond?
As they currently pleaded the case, yes. But
why is that? Explain that to me, please.
Because so right now, my understanding is, and my understanding based on arguments that have been made in the Hayes County Court, is that they have, in essence, abandoned the malicious prosecution part of the wrongful foreclosure claim or wrongful injunction claim and instead are going strictly against the bond. But that does not mean, however, that they could not, at least theoretically, have brought this claim in the Hayes County.
And can they, the counterclaim is still there, right?
Yes, yes,
And
Your
so they can just amend their counterclaim and add
Yes.
in whatever else they think they're not going to get here.
Yes, Your Honor.
Would they be statute of limitation out of amending their claim
Well,
at this point?
At least as to the tortious interference claim, our argument is yes, absolutely, they would be limited. And the reason for that is that the limitations period is a 3-year period that begins to run on the date of the breach. The breach that's alleged is the borrower's failure to go and I think attempt to get permission to sell the property to my client. That sale did not happen. There was, we're currently.
I like how you phrased that, his attempt to get permission, which he never did.
Right, well, that's exactly right.
There was no attempt.
No, no.
So what you're saying is when your client violated the contract and entered into an agreement without their permission, that's when it started.
No, Your
right?
Honor. No, my client didn't violate any contract. It's the borrower.
Because he got their consent?
No, the borrower, we're not a party to a contract with 417 North.
Okay.
My clients are not. There's a loan agreement pursuant to which the borrower and the former
So you
owner-
purchased,
We entered into a contract that, based on our best belief, would have satisfied the full amount of the loan as of the date of the closing. There was at that time.
your position was that your clients didn't know that the people you contracted with were supposed to get permission from them.
No, Your Honor, and I would also respectfully submit that, practically speaking, when there's $21 million coming to the table, and that is going to, by our calculation of the loan amount, would make the lender whole based on what.
That's not the issue, and that's never the issue in business.
Okay.
I'm gonna ignore what my contract says because I'm gonna get the money that no, that's not how business works.
I understand.
Come on.
Your Honor, but
Don't make arguments
we're
like
not.
that.
We are not. None of my clients are a party to a contract with 417 North Comanche.
Right, but your argument was they were gonna get paid, so it doesn't matter whether there was a breach of the contract. And that just is not the way business is done or should be done.
I understand,
right?
Your Honor.
Okay.
But we had no knowledge of what was going on with PSMP and 417 North Comanche. We were simply relying on the representations by the borrower that if we paid this amount, it would satisfy the amount of the loan. It's my client's position that because we're not in contractual privity with them and did not have
Yeah,
actual.
but that's, okay, those are defenses, right? But the question is whether or not the movant here or the appellant can assert those claims in Texas. And your position is absolutely, because the counterclaim for wrongful getting a preliminary injunction is still on the table. It still has to be litigated, and they could always amend their counterclaim and add whatever else they think they can.
Yes, Your Honor. As to the
And let me ask you this, are the parties the same here and there?
substantially, they are.
Are the underlying facts the same? The facts that
Absolutely.
support the claim there are the same? I guess additional facts would support and they knew and didn't. I mean, I don't know what Texas law is for breach of tortious interference. Obviously, here in New York, if you had a legitimate business reason, you wouldn't get any damages for, right?
Yes,
But-
Your Honor. And it is the same underlying facts.
Okay,
And
so,
we
but
could-
they could always bring that claim.
Yes, and
All right.
frankly, Your Honor, the statute of limitations period on tortious interference, I believe, is different in Texas.
Well, who knows if it relates back.
That's right. I just don't.
There's
I don't
a,
know.
you guys seem to love to litigate against each other, so.
Yeah, didn't an entity related to Emmett actually end up buying the property?
Yes, Your Honor.
Can't you guys work this out?
Your Honor, that's a good question. And,
I'm not supposed to ask that question. When you're a trial judge, you can ask that question, but not when you're an appeals
where
court
we are
judge.
today, though, Your Honor, is a Hayes County action.
But we think it.
There's a Hayes County action that alleges wrongful injunction. There was a New York Supreme Court action against my client, that's also a party to the wrongful injunction claim in Hayes County, and then added a bunch of entities that, according to 417's own allegations, work together for the purpose of EMRA's getting the temporary injunction. It is the exact same loan agreement. It is the exact same purchase and sale agreement. It's the exact same attempt to foreclose, and it is the exact same injunction that serves as the basis for the wrongful injunction claim.
Okay, thank you.
Thank you.
May it please the court. I'd like to make 3 quick points. First, With regard to what we could theoretically plead in Texas, there is no requirement to look at what theoretically could be pled there. We believe this is a New York case. We are a New York-based company.
Okay, where are the two companies from?
New York, Your Honor.
And where is the property at issue from?
The property is located in Texas.
Where did the alleged wrongful injunction get issued?
From a Texas court.
Over Texas property, right? Texas property, Texas wrongful injunction, which is by far is a big part of your and the tortiously interfered with me claim, right?
Not all of it, but yes, Your Honor.
Yeah, that's basically it. So it's Texas actions and Texas property, and you're telling me this is a New York case?
We believe it is based on the parties. But that leads me into my second point, which we think there are key facts here that are not at issue in the Texas case. That case has nothing to do with intent. Here in this case, for example, at record 2829, we allege vindictiveness by the principals, the individual defendants and their companies. We believe they were out to harm deliberately a competitor, go after a competing, again, New York versus New York, competing company out to harm us. And we believe those are key facts that do not overlap whatsoever with the bond claim in Texas.
But what does that got to do with the price of eggs, though? I mean, so they were taking glee in going after a competitor. I mean, how does that affect the contractual relations here?
Well, the point, Your Honor, is it's part of what makes the conduct here tortious. It shows their intent, which is a essential piece of the cause of action that does not overlap.
Thank you so much. Lee versus Lee. You may proceed.
May it please the court. I'm Lori McPherson. I'm counsel for the appellant Svetlana Lee. The trial court's decision to grant the respondent husband's sole legal custody and primary residential custody must be reversed on the grounds that, one, most importantly, the appellant was clearly deprived of a right to counsel. Two, the trial decision lacked a sound and substantial basis in the record.
Didn't the appellant actually request to go pro se after the court conducted an inquiry of the appellant?
She had no choice.
No,
she had a choice.
No,
she believed that it was imperative to resolve this so that she could move forward with her children, but she had a choice.
And the court actually gave her a number of options in terms of delaying the trial so that she could.
No, forgive me, but he did not. What was made clear in the record, and I can specifically point you to the appendix at 1960, lines 12 to 14, and the appendix at 2585. The trial judge granted the motion to withdraw on basically a mere fee dispute and failed to grant the appellant.
Well, it wasn't a mere fee dispute because I recall the attorney saying, this is not about money.
Well, if you read the record carefully, it is most certainly about money because it's clear that my client made it clear that she was proposed a financial proposal that she couldn't live with. But to answer the first question that you raised, the court would not grant any reasonable adjournment or stay to even permit her to try to find alternative counsel by informing
How many lawyers had she gone through at that point?
That's also misleading.
Let me just ask you. Well, okay, but
Two firms.
Two. So now she's on her third lawyer that she's.
No, Your Honor. In fact, Mr. Kornfeld, who made the motion to withdraw, was in the same firm as Meg Camby. So that's a misleading. She was not on her third lawyer, effectively. She was on her second lawyer. But this is what's so very, very, very important. There really wasn't a choice.
So there was a
choice.
Switch?
I'm sorry, Your Honor?
There's a switch between two lawyers at the same firm?
She first
still two lawyers.
She first worked with Meg Camby, and then Meg Camby left Mr. Kornfeld. Mr. Kornfeld picked up the case after she left, but they were together. It was the same firm that was there. But the most important thing here, Your Honor, is that the judge would not grant her any further time beyond the remaining 6 days. He would not, he made it clear that she had to decide whether to prepare with counsel in 2 weeks or go pro se. That's the appendix at 1951. He did not even grant her the minimum stay required under the CPLR 321C.
It's not a minimum stay. It's in the trial court's discretion. This is in the middle of trial, right?
It is, Your Honor.
Okay, and there, it's not a minimum. The trial court can pick less or more. That's the standard. But we're talking about, and this is what she says. What, if anything, you wish to do today concerning your right to counsel? I would like to keep the trial dates and appear pro se if I hadn't found a solution by then.
Right.
Was she lying when she said that?
No, Your Honor, but it was
So,
the only...
okay, the judge hears. I would like to think about that. I would like to keep the trial dates. So you're throwing this on the judge when he says to her, the judge, what, if anything, do you wish to do concerning your right to counsel? She says to the judge, I would like to keep the trial dates and appear pro se if I haven't found a solution. So why should he not take her by her state? Is she not? She's a college graduate.
Yes,
right?
Your Honor, but she's not a lawyer.
Highly educated.
But, Your Honor, it's simply not reasonable to think that an appellant could find competent counsel able to step into the middle of the husband's cross and finish a custody trial.
Why would she say that if she did not mean it?
Especially when the court follows up and says, are you sure? You have to pick up where Mr. Cornfield left off.
Yes, but he wasn't allowing her any additional time. He says there will not be a mistrial. We will finish no later than June the 13th, and these are the dates. He says on a number of occasions, I am retiring. I have no further time. This case must be finished. So what was she to do? She wanted a resolution. He was telling her there would not be a mistrial. There would be no additional time. She couldn't find anyone else. That is all just sort of...
So what is on the record that there was an attempt to find someone else? I didn't see that.
There was. It was me,
Okay.
among other things. And we made it clear, and we wrote to the judge asking if we could get a couple of months to get up to speed. This is a 6,000-page record, Your Honor. There is no
Counsel,
way...
you know how difficult it is to move family court cases. So a case that is already in the middle of trial, where experts have had all of these different testimony already, to repeat that all over, as opposed to taking a pause and giving time to find counsel but to ask for several months of an...
No, Your Honor, but there's no reason why the motion to withdraw was granted. It is clear that this was not an irretrievable breakdown. She had a right to counsel. Right to counsel is a fundamental right under due process.
We are aware.
I know you are. But I can't overstate enough the prejudice that occurred to her by virtue of having to go forward pro se to finish this trial. That was the only realistic option that was granted to her because she couldn't get...
In terms of the option, the judge did say he would give her 2 weeks, right?
2 weeks.
Is that a yes?
Yes, Your Honor.
Okay, thank you.
But it is a highly unreasonable demand, particularly since we're talking about custody. And the judge...
This was custody that was already in the name of the father. This was to add time, right?
No, there had not been, Your Honor, a decision on interim custody at all. And in fact, the attorney for the children and the guardian ad litem reported and recommended that my client, not the respondent, should get educational decision-making. That the children's voices should be heard and respected. There's a 15-year-old girl in the mix here. She couldn't have been more mature and articulate, and she said, I want more time with my mother.
Mm-hmm. Yes, I read the record.
Thank you, Your Honor. But that is also
You'll
the
have
reason...
time on rebuttal.
Thank you.
That's okay. Good afternoon, Your Honors. May it please the Court, Lisa Zeiderman on behalf of the respondent. So if I may, Your Honors, Judge Hoffman actually on March 7th, 2024, when Mr. Kornfeld had actually come in and ask to be relieved, tried very hard, and it's in the record, to actually repair the relationship that had broken. It was completely irretrievably broken due to Ms. Lee's accusations that Mr. Kornfeld had committed malpractice and had endangered her children.
And in the midst of, just because I want it to be real clear what happened here.
Yes.
In the midst of the judge trying to mend the attorney-client relationship, the client continues to claim that this lawyer was acting against her.
That is correct, Your Honor.
So clearly, when a lawyer is being accused of acting against their client, that lawyer has no choice but to step down.
That's correct. And in fact, Mr. Kornfeld did in fact try, and twice he went outside, and I believe that's in the record, and Judge Hoffman actually tried to repair it, but to no avail.
And that wasn't about a fee dispute, right?
No, it was not about a fee dispute. Mr. Kornfeld was very clear that it was not a fee dispute, that he could not go forward because trust had been actually broken at that point, and he had been accused of very heinous, there were very heinous accusations made against him, very specific accusations, and so he could not go forward. I will also say, this is a trial that the judge had said on March 22nd, which I believe is actually, I'm just looking to see, I think it's day 13 perhaps, that he had 95% of the information that he needed to make the decision. And so there were direct affidavits for the testimony for both of the parties as well as other witnesses. I believe there was one other witness that didn't have a direct affidavit, but all the other testimony was in. So this was more trial time than than it reflects actually, because all the directs were basically in except for one witness. And most of the cross was done as well, except for perhaps one day. And of Mr. Lee's cross that turned into several days by Ms. Lee, with Judge Hoffman actually trying to help formulate questions, etc. Ms. Lee was very clear on March 7th that she appreciated, in fact, the disadvantage and that the alternative to her was to endanger the children, and that she was going to go forward in a timely manner where Mr. Kornfeld left off, and that's in the record at...
I just want to, may I interrupt you? Because the one thing I think that my colleague raised and counsel raised is the daughter says, I want to spend more time with the mother.
Yes.
So why should that not be taken with a great amount of weight?
So I believe that Judge Hoffman, and obviously we weren't there for the in-camera, but Judge Hoffman noted in his decision that the children had been coached. And
Right.
so, and he also noted...
I mean, that was a credibility finding. He found that the children, that particularly the daughter had been coached. The daughter was talking about where the son should go to school, right? Okay.
That's correct, where Bill should go to school. In fact, it was, I believe, so coached that Judge Hoffman determined that although he wasn't going to have an in-camera for the child Billy, he decided to have the in-camera afterwards for Billy so that he would meet both children. And in fact, he noted that, and he certainly had the ability to know this because he had now had 15 days of trial, plus the directs, plus 4.5 years with these parties, for various motion practice.
And for the judge, the coaching manifested in a way that the children were saying exact things that had been said in the courtroom, and that's how he found the coaching, correct?
Yes, it was the language that the children were using that was very much like what the mother used in the courtroom, and so the judge could actually, as far as I could tell from the record, and that's from the decision, obviously, found that there was extensive coaching, that it was over an extended period of time. It wasn't even just that particular day. It was over an extended period of time that there had been actual coaching. And so, as a result, Judge Hoffman made his decision, and obviously he was able to note credibility and see the demeanor in the courtroom, and he was able to, he had hundreds of exhibits.
Even if the judge is correct that there was coaching, with respect to this 15-year-old daughter, 15 is a really important time for a little girl. And it's a time when a girl needs her mother. So why should this court not consider her request to spend more time with her mother?
So I believe that the court did consider it, but did not find it to be determinative. The court actually considered it as one of the factors, because otherwise it wouldn't have had the in-camera. So it did consider it, but given all of the evidence and given all.
I'm saying, why shouldn't we grant it, is my question to you.
Because-
I've got a 15-year-old who's saying, I want to spend more time with my mother at the most crucial time in her growing up as a teenager.
Because, Judge,
there are things she can say to her mother she can't say to her father.
I'm not going to disagree there, Judge,
Right.
except for the fact that this was a judge who actually could see all of the parties' credibility, their demeanor, the fostering or non-fostering of the relationship with the father.
Sure.
How much time does the mother get with the daughter?
So she gets 6 out of 14 nights, actually.
Oh, okay,
And
okay.
plus holidays and vacation time.
Okay.
So all of that is split the holidays. They each get 2 weeks of vacation time, and then 6 out of 14 nights. And so the court said that there was a substantial amount of time that the child was spending with the mother.
Okay, thank you. Counsel, you have time, yes?
The court could not have had enough information at the time that he allowed the motion to withdraw to be granted. It was 1 day of cross-examination of the husband. But more to the point, there was no question that there was no coaching here realistically. And all
Counsel, I read the transcript.
Okay.
6-year-old doesn't talk like that.
Fine,
I'm
Your Honor,
sorry.
but then I find it curious, respectfully.
The 15-year-old, I think you have a stronger argument. With the
Absolutely.
6-year-old,
But the AFC, Your Honor, the AFC, the attorney for the child and the guardian ad litem for the younger child, saw no reason to substitute judgment. If there had been coaching, that would have been his responsibility. Your Honor, I beg you to look at the appendix at 6464, which is the AFC's report. I think it speaks volumes here. and
Counsel,
shows
I have
a real.
a question from Judge Gonzalez, who's got a slight sore throat, so she's not able to articulate as much as she would like to. But she asked, is there any problem with the daughter's visitation schedule? How would you want to change it, I think, is the point of that question.
It should be flipped. It should be 8 days with her mother and the 6 with the father. This is what she wanted. She was very.
but doesn't that just completely disrupt the connection with the brother? I mean, because
I think they should go better, Your Honor. to
I
answer
think
your
family courts, and I never sat in family court, but I think family courts really try hard when dealing with custody and visitation to not split children up.
That's exactly right, Your Honor.
So now you're saying,
No.
because she wants to flip it on it for her and the little boy?
I think that, yes, and I think that the AFC makes it clear that he thinks that's the appropriate schedule here. He makes that very clear, and this is a very, very responsible, experienced AFC and guardian ad litem. I want to ask, if Your Honor, I would just answer one other question. There was the suggestion that she was making these horrible accusations. If you read more carefully into the record, it's just not clear. When the judge asks her directly, is that the only basis for you accusing him of malpractice or endangering the children? Is that correct, that he wants to withdraw? And she says yes. And she says, I need an attorney, and I'm not understanding his position on why he has to withdraw and why he believes he's not going to be paid. Separately, she says, I was made a proposal, a financial proposal, that I can't live with. And I'd like to find some other way to keep him. A litigant has a right, in custody matters particularly, has a right to counsel every stage of the trial. So if at any point there was a suggestion, oh, she was saying all this, and she said she wanted to go forward, throughout this trial, and I can give Your Honor appendix citations, she makes it clear, I made a mistake. I need counsel. She says, I apologize to Mr. Kornfeld several times for the miscommunication. I am mortified that the miscommunication between us resulted in me being without counsel and being in an impossibility to find alternative counsel. Appendix 2559, lines 15 to 19. She makes it clear that I'm trying, Your Honor, I'm trying, but I need time.
All right, we will take a look. Thank you.
Thank you, Your Honor.
Reyes versus Benton.
Your Honors, may it please the court, my name is Gina Longobardi for the appellant defendants. The lower court made an error in their decision to grant plaintiff's summary judgment motion based on the fact that there are several inconsistent statements between the parties and many material issues of fact.
Do I have a pedestrian inside a crosswalk when she gets hit? And isn't that in and of itself a VTL violation?
Your Honor, the VTL does state that the pedestrian has the right of way. However, the timing of when the plaintiff actually steps in the crosswalk is where the material issues of fact exist. There's another portion of the VTL, 1151.
All drivers are required they have a duty to see what there is to be seen. And when you're driving a school bus and you're making a turn onto a street, you got to make sure that there's nobody in the crosswalk. She's hit in the crosswalk.
Right, Your Honor, but when he makes his turn, she's not in the crosswalk, and that's where the issue is.
So she gets hit in the crosswalk.
Well,
but
the issue is, Your Honor, when the bus driver is already got his wheels on the crosswalk, that's when he observes the plaintiff step off the crosswalk and come into contact with the mirror of the bus. There is so many...
Those facts, were they reflected in the police report?
The police report does not state what the driver says. All the police...
No, he says, yeah, it says he agrees.
He just says he has similar statements. But
Okay.
Mr. Benton, during his deposition testimony, says he told the police his entire version of what happened, and the police didn't take that down into their police report.
Because it says he gave the same version of events as the plaintiff, right?
Well,
I mean, that's what the police report says.
Well, it says that he gave similar statements.
Right.
But
which means it's the same as what the plaintiff said, which is why there was no different account by the police.
But, Your Honor, the Mr. Benton, when he testified, completely disagreed with that. He basically
Mr. Benton
said...
also pled guilty to a VTL infraction, correct?
No, he didn't plead guilty. He ended up just paying the ticket.
That's a guilty.
Well, Your Honors, the issue
In VTL, when you pay, you are admitting guilt.
Your Honors, when he's testifying, he's saying the timing of this whole thing is extremely important because it's a complete he said, she said. If the plaintiff observed...
No, is he denying that she was in the crosswalk when he hit her?
He's denying that at the time...
Let me ask you these questions. Is he denying that the light was green for both of them?
The light was green.
So that's one. He's not denying she was in the crosswalk, right?
What happened was when she...
I'm asking you a simple question. I know you want to tell me something else, but I just want to know. He said she's in the crosswalk when I hit her, correct?
She walked into him. That's what she said. What he said, I'm sorry.
She walked into him.
Into the mirror of
pedestrian
his...
walking into the bus story.
Into the mirror of his bus.
And he is taking a right turn, and she is coming this way, right?
Well, there's another discrepancy. In fact, the bus driver actually says she's coming from a completely different direction than
Except
what
the medical reports confirm what she said.
And the police
medical reports show that she fractured her left shoulder.
Well, she could also have conducted that fracture if she came from the same direction that the bus
But the police report says she's coming this way, and he's turning this way.
She would have had to spin around before the hit.
Not necessarily if she's walking from the direction where the bus driver is saying.
So wait, so now we have the police report that says she's coming down this way, and your client saying, I agree with that. You have the plaintiff testifies twice, I'm coming this way, and he's turning this way, right?
Well, Your Honors, my client doesn't agree with the police report. That's the other issue. Whether the police report or whether the police took down and dictated everything my client said, that's another issue. The whole issue is that my client's version of what transpired is he had already made his right turn when he's already, two wheels of his shorter bus are already in the
But the problem is, it doesn't matter whether he had begun his turn. If there is a pedestrian in the crosswalk, he had an obligation to stop.
Your Honor.
And you can pick up from there on rebuttal.
Okay, thank you.
Okay?
Good afternoon, Your Honors.
Good afternoon.
Please the court, Anthony DiStefano for plaintiff respondent, Yaneli Rosado Reyes.
So what do you say about the bus driver saying that she came from a different direction? I'm not really sure what that means. I don't know how she could have come from a different direction, but.
I don't either, Your Honor, and I think that it's pretty clear based on exactly what was said in the police report, which was that the driver states a similar story to what the pedestrian stated.
And there's actually a picture,
Diagram.
a diagram, right? Good. A diagram of how the accident happened, right?
Yes, Judge.
And everybody saw that.
Exactly, Judge. And there's also testimony from the driver at page 358 of the record who said that he had a conversation with Ms. Reyes after the incident and I guess was trying to see if she was okay. And this is what he says. She said her arm, comma, I guess where the contact was made. That was her left arm. So he's now acknowledging that the contact was made with the left arm, even though he testified earlier that he believed he hit her on the right side. So he couldn't even get his own story straight at his deposition.
How could he have hit her on the right side? How could that have happened?
Not coming from the direction in the diagram and the statements in the police report, the testimony of my client, and the timing makes sense from where she was struck.
Where she was in the crosswalk, right?
Yes,
So
and he says
it's just
that,
like,
that
can't
she
figure
was
out
in the crosswalk.
where he could be talking about if everything else that everybody's testifying to is true.
Including, again, his own testimony on page 358.
Right.
You know, that he hit her where that her arm, where the contact was made, is what was hurting, and her complaints were of the left arm. So the contact was made on the left arm.
side.
Thank you, Your Honor.
You have 1 minute on rebuttal.
Thank you. Your Honors, while the VTL section 122.1112A does state the plaintiff would potentially have the right of way, if there's already vehicle in the intersection on the crosswalk, the plaintiff also owes an obligation to be careful for her own self when she steps into the
So you're saying the way the accident happened is the vehicle's like this and she walks into it like this?
Our position, our driver's position is that when he's making the right turn, she's coming from this direction, but he doesn't see her at the intersection.
Counsel, you
where
realize that if she's coming from the direction you just indicated, she would have been hit on the right side, not the left.
It depends on, because the bus is also moving at the same time.
If the bus is turning right, and your bus driver says she's injured on the right-hand side, then yes, she would have been coming from the right-hand side.
It depends.
But she fractures her left shoulder. Your client says that the bus impacts her where her arm was hurt. The left. Which means the pedestrian was coming from the opposite side. Going back to my first statement, he had a duty to see what there was to be seen.
But Your Honor, she also says she was 75% into the intersection. We know that's not true. We don't know exactly if the plaintiff turned her body at that point. We didn't even get into that point because those questions haven't been asked of her, and she also may not remember because she lost consciousness. But the point of the matter is that if the bus driver
we are to believe that she walked right into a bus,
into the mirror of the bus,
fractured her arm so hard that she knocked herself out in the process, all on her own volition. He was just there. She walked into it.
Well, it was raining, Your Honors, and there was a hood on. She had her hood on. She had an earbud in.
I thought it was an umbrella. I thought he said that he saw her with an umbrella.
He did.
Oh, so it was a hood and an umbrella.
Well, she testified she had a hood. He testified that she had an umbrella and that he knew that she had the umbrella because he helped pick it up after the fact.
Okay.
She testified she had the hood on and it's raining.
Got it.
Probably looking down.
We have your arguments. Thank you so much.
Thank you, judges, for your time. I appreciate it.
Have a good evening.
You too.
Wilmington Savings Fund versus Scafidi. Justice Gonzalez is recused. If we should have a tie, we will follow appellate division procedure.
Good afternoon, Your Honor.
Good afternoon.
Harold Pokel for Lila Rose Gordon for the appellant. This is a case involving FAPA. The court below.
I thought this was a case about the denial of a motion to vacate the judgment.
That's correct.
Foreclosure and
Yes,
sale.
Under FAPA.
Right.
And the court, I believe, wrongly decided that.
So, but our issue first, we have to deal with the issue of the motion to vacate the judgment. Was that done properly? Was that done timely, et cetera?
Well, Judge, it was done initially timely, and then it was denied, and the appellant moved to renew. That was denied with a full opinion. It was considered and denied. And then it was made again, another motion to renew. And that was also fully discussed by the court. It was taken under consideration, and the court denied it again. So I think it was completely timely. I don't think there was any problem with that.
Okay.
What happened here, the dates are a little bit important. The statute of limitations began to run on June 1st of 2007. That's according to respondent's brief, page 3. They concede that. Shortly after that, October 5th of 2007, the first foreclosure action happened. There were 3 foreclosure actions. The first foreclosure action, the one begun in 2007, was dismissed in 2012.
So Carmelo Scafidi.
I was on that
was
case.
not, yeah. Carmelo Scafidi is only on the 3rd foreclosure action, correct? He wasn't a named party in the first 2.
That's absolutely correct. Well, he was named, but he was named in the capacity as a potential heir, but not as the executor at all. So Bianca Scafidi died, and the plaintiff sued her again in 2013. However, she was dead, obviously. So then the plaintiff had to decide what to do. So it did not ask for the substitution of the executor, which would have been the appropriate thing to do, and I think what was required to do under the CPLR. Instead, the bank tried to do a kind of an end run around the statute of limitations. What it did was because the statute of limitations had run by that time in 2015. So what the bank did was they sued the executor, and then they asked the court to combine that case, the case against the executor now, with the 2013 action that had been wrongly brought against the deceased. That way they thought they could save 2 years on the
Was the
statute of
deceased the
limitations.
only defendant in that matter?
I'm sorry?
Was the deceased the only person in that, the only defendant in that action?
No, there were various other people who were designated, like city agencies.
So when did that happen? When did the consolidation of the action?
2017.
And at that time, did anyone appeal that?
There was an appeal. I don't.
And it was
think
abandoned, right? It was well, in our court records, it was dismissed as abandoned.
Yes.
So once that's dismissed as abandoned, and now 8 years later,
That's law of the case. We're stuck with that.
right? You're stuck with it. So this argument that there should not have been a consolidation, you should have appealed it at the time. You didn't. Now it is what it is.
That ship has sailed, as they say.
We're saying something a little different, though. We're not at this.
No, I think you're saying exactly that. You've tried this three
We
times.
cannot revisit, and we will not entertain that.
I understand that.
Okay.
You're saying, though, that the statute of limitations simply ran. It started running in 2007. The consolidation was in 2017. That's 10 years in the statute of limitations.
And did you, when that happened, did you assert statute of limitations?
Not at that time, because FAPA
Have you
hadn't been
ever,
passed.
before the judgment was entered, did you ever assert statute of limitations?
No, because the
So
judgment
once the judgment is entered and you haven't asserted statute of limitations, haven't we held more than one time that that's a waiver?
Judge, yeah, in a sense.
Have we not held that, or yes or yes? I think we have. I think you admit we've held that.
Here's the problem, though. It couldn't have been the defendant couldn't have raised the statute of limitations in his answer, which is what the court says he should have done, or he should have raised it before the time to appeal. And he couldn't do that because FAPA wasn't in effect yet. So it seems to me he is entitled to a day in court on the issue of FAPA, and he got it, and that was wrongly considered. We raised consolidation here, but the real issue.
You're saying that FAPA revives actions that have already been completed? What case says that?
No,
We have held that if there is an open case, if it has not come to final judgment case, if it is in the middle of appeal case, then we can consider the arguments you're making. But that's not this case. This case was completely resolved.
I don't think.
And yes, I was on the case. Okay? And so you are trying to revive something that, as far as this court was concerned, was done.
But
the only thing we sent it back for was a recalculation of the amounts due. That's it.
I agree, but the statute of limitations, notwithstanding the consolidation, the statute of limitations started in 2007. It ran out. For putting aside the consolidation, it simply ran out.
All right. You'll have time on rebuttal.
Okay. Thank you, Your Honors.
Counsel?
Good afternoon, Your Honors. Ruth O'Connor, on behalf of the respondent. There are several insurmountable legal issues.
Does FAPA apply to invalidate your judgment?
No, it does not.
Why not?
Well, first of all, there was a motion to renew, which was filed long after the judgment was entered, and an appeal was affirming it was laid down by this court. So under CPLR 2221E, it's untimely. It was an untimely
Certainly,
motion.
right, we had an argument before about a property right. You have a property right in a judgment giving you the right to foreclose on property, and then you can't go back and undo that by a new statute, can you?
No, that's correct, Your Honor.
That's pretty straightforward.
I do have one point to make. It was in our underlying papers. The statute of limitations had not run by the time, notwithstanding the fact that the appellant didn't oppose the motion to consolidate and didn't appeal it. And the statute of limitations hadn't run by the time we commenced that 2015 action.
Well, the debt was accelerated in 2007, right?
Right, it was accelerated in 2007.
And the law at that period of time was if the case was discontinued or dismissed, that it would decelerate, right?
But the borrower died. It was
right,
arguably
okay.
told for
Right,
the
right, right.
period, for
Right.
18 months.
Right.
So the 2015 action was commenced on January 29, 2015. And with the tolling, the expiration of the statute of limitations was April 5th, 2015. So regardless of everything else, the basic premise that the 2015 action was violative of the statute of limitations is not factually true. I have nothing further. Thank you.
Thank you so much. Okay, counsel, you have a minute on rebuttal.
Thank you. The statute of limitations, in fact, ran out in 2013. It didn't run out after the 2015 action at all. It had already run out.
Well, that 2013 action was commenced, right?
It was commenced, but it was commenced not against the executor of the estate. It was commenced
Okay, but it was commenced against other parties who had an interest in the property, correct?
not against the estate. The estate
But so why couldn't you just bring the estate in later and have the claims relate back? We do that all the time.
apparently that's what was attempted here, but
I mean, isn't that what the relation back statute says? If you bring somebody in later on the same action or series of transactions, that the claim relates back to the original filing?
But I'm not sure that the estate is absolutely identical to the deceased.
No, I agree, but the claim is the same, right?
claim is, the foreclosure claim would be the same, yes. In that respect, it would be the same.
Thank you.
Thank you, Your Honors.
Bodenchak versus 5178 Holdings, last but not least.
Yeah, grab a quick slug of water first.
Go right ahead.
Oh, thanks. Yeah. I can't. Oh, yeah, there it is.
You may proceed.
Thank you, Your Honor. Good afternoon. My name is Jonathan Kortmansky, representing the appellants. We're here today because the trial court below allowed a non-member of an LLC with an interest only in the profit distribution from the LLC to exercise the power to dissolve under 702, which is a membership power only, an ongoing business.
Just to stop you there, on LLC 702, doesn't it say that it can be brought by or for a member? So she's bringing it for a member.
So, thank you, Your Honor, for the question, and I will answer that directly, which is, it says on behalf of a member, and the issue is when someone dies, unless that membership is assigned, they are no longer a member, and the only interest left of the former member.
And does
is an
your
income stream
agreement,
under- oh, sorry. Yes,
is
Your
there
Honor.
anything in your agreement that says that? That,
Absolutely. The agreement does not provide, an agreement under CPLR, excuse me.
counsel,
under the
I'm talking
LLC.
about, this will work better if you allow us to talk.
Yes, Your Honor.
Okay. So there was an arrangement here between the decedent and your client, correct?
By an arrangement.
They were in go ahead.
There was an operating agreement.
Right. And in that operating agreement, does it speak to what happens when a member dies?
Yes, it says that the membership interest is not assigned.
Okay. What else does it say?
It says you're entitled to an income stream.
Okay. And how does that interplay with state law in New York?
It's consistent with state law in New York. State law in New York, under LLC 603, says if there's no assignment and there's no vote to make someone a member, then the only interest that's left is an income stream. So
No, that's not what it
Well, it
says
says
at all.
profits and-
That is
profits
not what
and-
it says. It says, I get the right to resolve whatever issue is going to be, has to be resolved to get the estate finished up. That's what the EPTL says. It's entirely consistent to say, yes, you're not a voting member of this organization. You get a membership interest assigned to you. You get the profits and loss. But it also says, here's the one thing. You get to finish up whatever you need to finish up to resolve the estate. And that's exactly what's happened here.
With all due respect, Your Honor, it does not say that.
Oh, I think it does. I mean, you and I will have to disagree about that. I think the EPTL is clear.
If I may.
Counsel, what about the Limited Liability Corporation Law 608? What does that say about an administrator or when a member dies?
So 608 specifically says, and that's a great question, Your Honor, because it actually highlights the issue. 608 specifically says that, I'm sorry, I'm just going to turn to it in my notes so I can read it for you. It's a limited purpose statute. It provides that a member's executor may exercise all the member's rights for the purpose of settling his or her estate or administering his or her property, which is only the profits at this point, because there is no membership anymore. And then it goes on to say, including any power under the operating agreement of an assignee to become a member. But that doesn't exist here. There is no power under this operating agreement to become a member. And there's a, oh, sorry, Your Honor, please.
Because I think a membership interest in the LLC is personal property, is it not?
Mm-hmm.
And therefore, it would be subject to estate powers and trust law, which means, the administrator succeeds to the property right and gets to do what
If I may, Your Honor.
Please.
um,
What about
see I'm out of
601,
time.
first of all?
There's two different statutory schemes going on here, and the EPTL has been very clear that when it is assigning a direct right to bring a claim, it's express. In fact, it expressly states in the EPTL that you can continue to bring claims for an injury to personal property.
Okay, but the
That's not
state
this.
is not bringing a claim. It is not seeking to exercise its a right as a member. It is simply seeking to finish the claim so that it can get the property that the estate is entitled to.
If I
And
may,
you'll
Your Honor.
have time on rebuttal, because
Okay.
we've gone over.
Thank you, Your Honor.
Good afternoon, and may it please the court. Michael Stanton, Kosikoff, and Cataldo on behalf of the respondent. Your Honors, the statutory schemes are simple, and it is not a close call.
Your client's not trying to exercise its right as a member to like kick anybody out or buy a property or not buy a property or pay a $500 bill or not pay it, right? There's nothing going on like that.
Not on this application.
Prior to the death of the
Decedent.
decedent, your client, the decedent sought to dissolve right?
Correct, and
That's the only way that this estate is going to get its share of this property, correct?
Correct, and in fact, they've made their position very clear. They want to hold this property indefinitely. They don't want to sell it. And so their position.
Right, and they're not, and are you getting an income stream from it?
Of course not.
Of course not, right. That seems pretty clear.
Correct, Your Honors. And I don't want to belabor this point, but I also want to make an important one, which is that this court does not even need to reach the issue of the interplay between the EPTL and the LLC law, because the application below was a substitution motion. The court had two options, either grant or deny it. The appellant here wants to dismiss the case entirely, which is relief that neither Supreme Court nor this court could grant in the absence of a cross motion. Supreme Court properly held as much. There are a number of arguments that have been raised here, but ultimately I want to focus on two things. One is the plain text of LLC Law 608, which is conjunctive. It says you exercise all the members all of the rights, including dissolution, that a member had. And the other is the Second Department case of Matter of Andrus, which we cited and quoted to extensively in our brief. The Second Department has explicitly held that an estate may commence a dissolution action. Here, we're a step removed from that. We're merely maintaining the action
One that was already started by the deceased.
asserted. Correct. Your Honor, I would be remiss if I didn't address something that my colleague accurately pointed out, which was a botched quotation in my opposition brief that was to a Delaware case. I take full responsibility for it. The only explanation I have is that there are 127 footnotes in that case, and I miscited to one and misquoted as well. So I apologize for that. But I would say that otherwise, that case completely undermines the appellant's position on this appeal. I'm happy to answer any further questions, but otherwise I'll rest on my brief.
Thank you.
Thank you.
Counsel, you have 1 minute.
Thank you, Your Honor. When Mr. Bodenschak died, several things happened. First thing is his membership ceased to exist. The second thing is that his claim was actually extinguished. That is New York law, plain and simple, and there is no case in the First Department, the Second Department, the Court of Appeals that has held otherwise, that you can substitute an executor under 608. You'd be the very first court to do it when a claim has already been extinguished and the party to be substituted is not a member. And 608, plain as day, does not make them a member. It gives them certain very limited rights to administer the estate. The only asset of the estate is an income stream. And Your Honor, to answer your question, if the property is sold, because it's not required to be sold under the terms of the operating agreement, then the estate will get its percentage interest of the income from that sale. That does not give the estate, which is, I see I'm out of time, Your Honor, if I may finish.
You're talking to me, I'm the center chair.
I was
answering a question I
the
asked before, but
question to-
counsel,
Yeah.
exactly.
Yes, you may
huh?
continue.
Thank you, Your Honor. It does not give the estate, which is not a member, to assume membership rights set forth in a different statute subject to a statutory scheme that required 608, 702, and 604, which addresses how you become a member, to all work together. And if
Thank you.
Thank you.